Introduction. A basic principle of emergency care is to do no further harm. Do no further harm to your patient. Always act in the patient's best interest and act in good faith. A healthcare provider usually avoids legal exposure if he or she acts in good faith according to an appropriate standard of care. So if you function within your scope of practice and you are functioning within the standard of care and you're following your guidelines that your medical director has given you as standing orders, then you shouldn't have any legal problems. Once you start to deviate from that, then you might have some legal issues. Now, consent. Consent is permission to render care. A person must give consent for treatment. If the patient is conscious and rational, he or she has a legal right to refuse care. So a patient can refuse care, even if it's a life and death situation, as long as that patient understands that if they don't get the care that is being offered, they can die, and they understand the seriousness of their illness or injury, and they still refuse, it is their right. Now, foundation of consent is decision-making capacity. So, can the patient understand the information provided? Can the patient make an informed choice regarding their medical care based on the information provided? Patient autonomy is the right of the patient to make decisions about his or her health. Now, express consent. The patient acknowledges he or she wants you to provide care or transport. To be valid, the patient must provide informed consent. You have explained the treatment risk and the benefits to the patient, and the patient completely understands what's occurring. Implied consent applies to patients who are unconscious, otherwise incapable of making informed decision. So if they're unconscious, we assume that if they were, they would want treatment. Should never be used unless there is a threat to life or limb. Principle of implied consent is known as the emergency doctrine. Try to get consent from a spouse or relative. Involuntary consent. This applies to patients who have mental illness or are in behavioral crisis or they are developmentally delayed. Obtain consent from their guardian or conservator. Not always possible, so understand local provisions, and if it's not clear, then you probably need to contact your medical director for guidance. Now, minors and consent. A parent or legal guardian will give consent. In some states, a minor can give consent. So if it's a emancipated minor, meaning they're married, a part of the armed services, or they are parents, then they can give consent on their behalf. Teachers and school officials may act in place of parents. If a true emergency exists and no consent is available, treat the patient, consent is implied. Now, forcible restraint. Sometimes it is necessary to restrain a patient if they are combative, and it is legally permissible. You must consult your medical director or medical control, and you will involve law enforcement. And if the patient is going to be forcibly restrained, it has to be done in a way where there is no further harm caused to the patient, or you don't put the patient at risk of death, because there have been situations where persons have been restrained and died. Once applied, do not remove restraints en route unless they pose a risk to the patient. Consider calling ALS backup to provide chemical pharmacological restraint. Basically, they're going to restrain the patient with medication, sedatives. The right to refuse treatment. Conscious, alert adults with decision-making capacity can refuse treatment. They have the right to refuse treatment. They can withdraw from treatment at any time, even if the result is death or serious injury. I already emphasized this earlier. Calls involve refusal are frequently litigated, and yeah, these are the calls that can end up in court, or most often end up in court. Involve online medical control and document this consultation. So definitely need to get your medical director involved or medical control involved. Assess the patient's ability to make an informed decision, ask and repeat questions. Assess the patient's answers, observe the patient's behavior. If the patient appears confused or delusional, you cannot assume that the decision to refuse is an informed refusal. So if the patient appears as if they're not fully understanding what you're saying, they can't refuse care. Can't. Providing treatment is a much more defensible position than failing to treat a patient. Very important statement. So providing treatment is a much more defensible position than failing to treat a patient. Do not endanger yourself. Use the assistance of law enforcement. Before you leave a scene where a patient, parent, or caregiver has refused care, encourage the individual again to allow care. Ask the individual to sign a refusal of care form. A witness is valuable in these situations. Document all refusals and document properly. Confidentiality. Confidentiality information includes the patient's history, your assessment findings, and the type of treatment that you provided based on your assessment findings. Information generally cannot be disclosed except, so these are the exceptions, if the patient signs a release form, if a legal subpoena is presented, meaning it's going to end up in court, if it is needed by a billing personnel. Health Insurance Portability and Accountability Act of 1996, also known as HIPAA, contains a section on patient privacy, strengthens privacy laws, safeguards patient confidentiality, considers information to be protected, health information. Failure to abide by the provisions of HIPAA laws can result in civil or criminal action. The general public is often permitted by law to record identifying and protected patient information and images. Social media, big issue in the next generation. Social media is going to be the end of humanity one day. Social media, avoid agency logos, uniforms, vehicles, or other markings associated with your agency while off duty. Conduct yourself professionally on and off duty. And there are some companies now that will check their potential employee social media links to see what they're posting. So be careful of what you post on social media. Conduct yourself professionally on and off duty. Free speech does not mean that everyone has the right to say anything under any circumstances and without repercussions. As I always say, our actions have consequences, and the consequences can be good and bad. And the truth is, some of us spend way too much time on social media pretending, right? So that time and energy could be directed elsewhere, improving your career as a responder. But some persons cannot, in this day and age, do without social media. Now, advanced directives. An advanced directive specifies treatment that should the patient become unconscious or unable to make decision, these directives will guide what is done to the patient. A do not resuscitate DNR order is an advanced directive that gives permission to not resuscitate. So if the patient presents pulseless and not breathing, the DNR states that they should not be resuscitated. They should not get CPR. Now, there are various types of DNR, and it can be very specific. So read up on it, and there are certain things that you need to look for on the DNR. It can be a out of hospital DNR, it can be an in a hospital DNR. As I say, it can be very specific. Now, other names for advanced directives, it can be referred to as a living will or health care directive. DNRs or DNR orders must meet the following requirements. So, statement of the patient's medical problem. There must be a signature of the patient or a legal guardian. There must be a signature of a physician or healthcare provider, and it must be within date. It should not have expired. Physician orders for life-sustaining treatment and medical orders for life-sustaining treatment. These are more detailed directives, explicitly describe acceptable interventions for the patient. They must be signed by an authorized medical provider. Contact medical control for guidance. Some patients may have named surrogates to make decisions for them, durable powers of attorney for healthcare, also known as a healthcare proxy. So this person is able to make decisions on the patient's behalf if it is health related. Due to the growing number of hospice home health programs, you may face this situation. Now, physical signs of death. A physician determines the cause of death. Presumptive signs of death would include unresponsive to painful stimuli, lack of a carotid pulse or heartbeat, the absence of breath sounds, no deep tendon or cranial reflexes, so the reflexes are absent. These are presumptive signs of death. Doesn't necessarily mean that biological death has occurred. Continuing with the presumptive signs of death, absence of eye movement, no systolic blood pressure, profound cyanosis, lowered or decreased body temperature. Now, the definitive signs of death. If you see these signs, the patient is definitely dead. A body in parts or decapitation, dependent lividity, and that means the blood or the body fluids is settling based on gravity. Rigor mortis, which is stiffening of the skin. This occurs between 2 to 12 hours after death. Algor mortis, which is cooling of the body until it matches the ambient environment, and putrefaction, which is when the tissue starts to break down or decompose. This occurs between 40 to 96 hours after death. Medical examiner cases. So there are some cases where a medical examiner might be required. Involvement depends on the nature or scene of death. Examiner notified in cases of death on arrival, death on scene, death with previous medical care, suicide, violent death, poisoning, known or suspected. Death from accidents, suspicion of criminal act, infant and child deaths. Organ donors. Organ donors express a wish to donate their organs, evidenced by information on organ donor card or driver's license. Your priority is to save the patient's life. Remember that organs need oxygen. Medical identification insignia. It can be a bracelet, necklace, keychain, or card, and this indicates a medical order. It can be allergies, it can indicate a medical condition, diabetes, epilepsy, or other serious conditions. Some patients wear a medical bracelet with a USB flash drive. I don't believe I've ever seen a medical bracelet in Jamaica, but I'm sure it exists. Someone has it in Jamaica. I've definitely seen it in the States. No, special situations. The patient may be carrying a medical identification card or wearing a bracelet or necklace that indicates important medical information and possible DNR orders. In the case of medical alert, the EMS provider can obtain stored patient history information from the Medical Alert Foundation. Now, scope of practice. Kind of touched on this already. It outlines the care you are able to provide based on your level of training, usually defined by state law. So the government basically dictates the scope of practice. The medical director further defines by developing protocols and standing orders. And remember what I said previously. Your medical director can limit your scope of practice, but the medical director cannot expand the scope of practice. Now, carrying out procedures outside the scope of practice may be considered negligence, or it is a criminal offense. And negligence simply means you fail to provide care for a patient that your level of provider is trained to provide, and it results in harm to the patient. But there are some things that must be present for negligence to be proven in court. So standard of care, the scope is what you're allowed to do based on your level of training. The standard of care is how you execute the skills based on your level of training. So standard of care is the manner in which you must act or behave. You must be concerned about the safety and welfare of others. Standard of care are established by local custom and laws, statutes, ordinance, administrative regulation, or case law. Professional or institutional standards, example, AHA CPR guidelines, can be textbook, example, the National Highway Traffic and Safety Act. I don't remember if it's Act or something else. But the textbook that you use is based on a particular standard that is governed by research. Now, standard of care established Standard imposed by states, Medical Practice Act, certification, licensure, credentialing. And in Jamaica, I believe we don't have any standard of care that is imposed by the government. So there is no standard where EMS operation is concerned in Jamaica. I believe the Ministry of Health does require EMTs that now work with them to be current. So that is a requirement, but there are some inconsistencies there. There are some inconsistencies. Now, when it comes to licensure, only a government can issue a license, so only a government organization. And if it is not a government organization completely, the government is going to have a role in it, just like the National Nursing Council. So the government plays a role in the National Nursing Council, and then you have nurses that make up that council as well, and they are responsible for issuing license based on government requirements. So we are way behind in terms of licensure, credentialing, and certification for EMS responder. And as I stated previously, if it is not addressed, we're going to get to a point where we don't need EMTs because the inconsistencies are too extreme. And it has started to occur where the medical fraternity doesn't have any confidence in EMS response because of the inconsistency in their skills and training. And it's going to get worse. It's going to get worse over time. So if there's no regulation and accountability for EMTs, then it's going to get worse, right? So the regulation is necessary for training. So training has to be regulated. It has to be based on the current standards. For instance, I have to now use the 12th edition text and curriculum. I cannot use the old curriculum based on the current standards. There are certain things I will now have to teach EMTs based on the new standards. So the training must be standardized. And then when these EMTs go out in the field, what should happen is the government should offer a testing process, a standardized testing process that would evaluate EMTs' skills and knowledge. And based on their performance, they're issued either government certification or license to function in the field. And they would then be required to maintain, I believe it's continuing education. So just like the nurses and doctors, where you have to submit a certain amount of hours in order to renew your medical license or nursing license. And it's very specific now. It never used to be specific for nursing, but it's starting to become very specific, meaning they have to cover specific topics. They have to have continuing medical education in specific areas. It has always been specific for EMTs worldwide who function in proper systems. So as EMTs, you're actually required to submit 78 hours of continuing medical education. For all of the levels, they have to submit hours in order to maintain their registry certification and licensing. But as I said, nothing exists currently in Jamaica. It's a free-for-all. Now, in order for negligence to be proven, there must be a duty to act, right? So duty to act means you're on duty. You're on duty as an EMS responder and you get a call, that's your duty to act. Individual responsibility to provide care, duty to act applies once your ambulance responds to a call, once treatment is begun. And once you initiate treatment for your patient, you cannot stop until you hand over to someone at your level or higher. Failure to do so can cause issues legally. So negligence, this is failure to provide the same care that person with similar training would provide in same or similar situation. Right? So you fail to put in an OPA, and that's within your standard of care and scope of practice, and the patient dies. You can be charged for negligence if they can prove that you had a duty to act. There was a breach of duty. There were damages as a result of that breach, and they can prove that what you did not do or what you did cause damage to the patient. Then you can be sued for negligence. So 4 of the following elements must be present for negligence to apply. There must be a duty to act. There must be a breach of duty. There must be damages as a result of that breach. And the court must be able to show that the damages are related to the breach that you committed as a responder. Now, res ipsa loquitur is French. The cause of the injury in the control of the EMT, cause of the injury in the control of the EMT generally does not occur unless there is negligence. So what res ipsa loquitur means basically is it is obvious. So whatever occurred is obvious. They don't need to even go into any details to prove anything. It's obvious that you did something that caused harm to the patient or you didn't do something. Negligence per se, the conduct of person being sued, is alleged to that occurred in clear violation of a statute. Right? So the negligence per se means whatever was omitted goes against some type of law or regulation. Maybe you went outside your scope of practice. Maybe you didn't put on a C collar when it was necessary. Patient damaged their neck as a result, cervical spine as a result, causing complication to their extremities. And then you have your torts, which are civil wrongs. Now, abandonment, this is unilateral termination of care by an EMT without the patient's consent, making provisions for continuing care. So, as I stated before, once you have initiated care, you cannot end that care for the patient unless you hand over to somebody at your level or higher. You cannot hand over a patient to someone below your level of training. That's abandonment. Abandonment may take place at the scene, in the emergency department. Always obtain a signature on your patient care record, and don't try and play Superman, right? So if you're off duty and you come up on a scene that requires some level of EMS response, if you recognize that additional resources will be required, do not go there and play Superman. It's better you call for additional resources if it's available, or you move right along. Once you have initiated care, you cannot stop. The patient is now your responsibility. So once you go on a scene and identify yourself as a responder and initiate care, that patient is now your legal responsibility. Now, assault and battery and kidnapping. Assault, unlawfully placing a person in the fear of immediate bodily harm, example, restraint. Battery, unlawfully touching a person, example, providing care without consent. Kidnapping, seizing, confining, abducting, or carrying away by force, example, transport against will. False imprisonment, unauthorized confinement of a person. Now, defamation, this is communication of false information that damages reputation of a person. It can be slander, which is spoken, or it can be libel, which is written. The Good Samaritan laws and immunity. If you reasonably help another person, you will not be held liable for errors or omissions. However, so what this is basically saying is that there are laws that exist that will cover you if you decide to stop and help someone in need. However, there are some conditions that must be met. So you must act in good faith. You must act without expectation of compensation. It must be within your scope of training and, of course, standard of care, and did not act in a grossly negligent manner. So you cannot do something that is going to cause harm to the patient. Gross negligence, conduct that constitute willful or reckless disregard. Immunity statutes apply to EMS systems that are considered governmental agency. Sovereign immunity provides limitations on liability, and immunity is not complete. So there are some statutes that after a certain amount of time has passed in years, they can prosecute, right? Those exist. Records and reports. Compile a record of all incidents involving sick or injured patients. If it wasn't documented, it wasn't done. Important safeguard against legal complication. Courts consider an action not recorded was not performed. So if it wasn't written, it wasn't done. Incomplete or untidy reports is evidence of poor emergency medical care. Proper spelling, proper grammar, all of that is going to be important. And if you don't know to spell a word, then you probably might try and use a more simple term or Google it. This is what you might need to use Google for. These are things that lawyers will look for in report. Spelling, grammar issues, inconsistency, your personal assumptions. These are things lawyers look at to decide if they're going to take a case. National EMS Information System, NEMSIS, provides the ability to collect, store, and share standardized EMS data used to improve the speed and accuracy of data collection. Special mandatory reporting requirements. Most states have a reporting obligation, and things that definitely need to be reported: abuse of children, older persons, and others, injury during commission of a felony, drug-related injuries, childbirth, attempted suicides, dog bites, communicable diseases, assaults, domestic violence, sexual assault or rape, exposure to infectious disease, transport of patients in restraint, scene of a crime, the deceased. Ethical responsibilities, ethics, philosophy of right and wrong, moral duties, and ideal professional behavior. Morality is a code of conduct affecting character, conduct, and conscience. Bioethics specifically addresses issues that arise in the practice of health care, ethical issues. Ethical responsibilities require you to evaluate and apply ethical standards, your own and those that are based on your profession. Allow rules, laws, and policies to guide your decision making. We don't operate based off of what we feel alone. We are guided by our training, or medical direction, or scope of practice, and our standard of care, and our genuine concern for our patients. The EMT in court. You can end up in court as a witness or a defendant. It can be civil or it can be criminal. And it's not going to happen right away. It might occur a couple of years after. Whenever called to testify, notify your service director, legal counsel. As a witness, remain neutral, review run report before court. As a defendant, an attorney is required. Defense may include statute of limitations, meaning too much time has passed. It can be granted governmental immunity, or it can be contributory negligence. Contributory negligence means the patient contributed to whatever damages or injury they receive. Now, I didn't point this out earlier, but one of the things that also is a part of duty to act is you must be current. So when you respond to provide respond to provide treatment for a patient, you should not be responding and your certification has expired. That would be a breach of duty. So just keep that in mind. So that can become a legal problem, which is very common in Jamaica. This EMTs in court continuing. Discovery allows both sides to obtain more information through interrogation or interrogatories, written requests or questions, depositions, oral requests or questions. So there is a phase where they're going to look at the information, do their research, gather whatever information they need, talk to persons who are going to testify, all of that. And then potential persons who are going to testify, and they will decide if they want to settle out a court, or it's definitely something that they want to take to court. Most cases are settled following the discovery phase during the settlement phase. If not settled, the case goes to trial. Damages that may be awarded, it may be compensatory or punitive punishment. Any EMT charged with a criminal offense should secure the services of a highly experienced criminal attorney immediately. And that would be the end of this chapter.